Welcome to the InfoSec Insider podcast, brought to you by URM, the UK's leading information and cybersecurity specialists.
Hi, my name's Annie and I'm today here with Stuart Skelly, who's one of our Senior Data Protection Consultants here at URM. Welcome to another episode of InfoSec Insider Talk DP. So today Stuart and I are going to be talking about STARS. So Stuart, I've heard a little bit about STARS. That it's a new information providing standard or duty for social housing providers. But what does it actually mean?
Hi, Annie. Yes, STARS stands for the Social Tenant Access to Information Requirements. And it's a policy statement which was introduced by the UK government under the Ministry of Housing, Communities and Local Government. In spring of 2024, last year, it was put forward for public consultation, this policy statement, STARS, as a foundation for a proposed new regulation aimed at benefiting tenants of private sector social housing providers in England and Wales. So that's an important point to note. It doesn't extend to Scotland or Northern Ireland, this STARS standard. And what do we mean by social housing? Well, that's rent-controlled, leased housing for people who are on low incomes, for example, or who have special needs such as medical conditions or disabilities. Now, in July of last year, this consultation period ended. And so we're now awaiting the government's activating some existing legislation, actually, to bring the STARS requirements into effect, to create a new legal access to information standard with which private social housing landlords will have to comply. So that the law already exists to facilitate the STARS. It just has to be activated. And that will happen later this year. And
what issue is the new STARS standard designed to address?
So basically, the intention behind the STARS is to plug what you might call an information rights gap experienced by social housing tenants whose landlords are private sector, what are known as private registered providers, or PRPs. Now, these are predominantly housing associations rather than local authorities, which are the other main provider of social housing in England and Wales. Social tenants who rent their homes from local councils, which are classified as public authorities under the Freedom of Information Act 2000, currently those sorts of social tenants have the right to submit Freedom of Information, or FOI, requests to their local authority landlords. And this statutory FOI right grants them access to a wide range of information about their homes, among many other matters. On the other hand, people who rent from housing associations do not benefit from the Freedom of Information Act because those housing associations, as private sector organisations, aren't covered by the Act. And as such, if these people who rent from private sector providers like housing associations, if they wish to make a formal request to their landlord for information, they're not entitled to submit an FOI request, but instead they must rely on what's called a data subject access request, or DSAR, under the Data Protection Act 2018. Now, although it is quite a strong right, a DSAR is not very broad, as it only relates to the requester's personal data. That's what data protection is all about, protecting people's personal data, information about them as an individual. The aim is for the STARS standard to address this shortfall between the right to make an FOI request, which currently only council tenants enjoy, and the DSAR right, which residents of housing associations are limited to relying on at present. The Ministry will achieve this purpose through the Secretary of State for Housing and Communities, Angela Rayner, instructing under a power she has in the Housing and Regeneration Act 2008, the regulator of social housing, or RSH, to introduce a new standard for housing association landlords to be more transparent with their information that could be of use and interest to their tenants. The stairs will be published under a power already contained in Section 22 of another existing law, the Social Housing Regulation Act of 2023.
So can you give me some ideas of what basic rights the stairs, which have been brought in by that regulator you mentioned?
Yeah, oh yeah, the RSH, the
Yes.
Regulator of Social Housing.
Yes,
Yeah,
thank you, Stuart.
sure.
Yeah, so what rights will that give to tenants living in private sector run social housing, and what sort of information requests are you expecting to be popular with people who are using their stairs rights?
Yes. The new standard brought in by the RSH, the regulator, will enable housing association residents to request data about the management of their homes. It will set specific time periods for responses, and it will also require housing associations to publish certain information proactively via what's called a publication scheme. We at URM expect the types of information that will be requested by social tenants under the stairs right to include information on the condition of their property, repairs and improvement plans, patterns of poor property conditions within a block or district, repair times, antisocial behaviour cases and outcomes locally, health and safety issues, breaches of housing association or other policy, outcomes of property inspections, basic property estate management, the names and job roles of senior employees of the housing association, the decision makers, in other words, policies and procedures, spending on property, housing stock management, performance standards, rent rates, and service charges for shared owners. So quite an extensive portfolio of different sorts of subjects and topics which we are expecting tenants of housing associations will be able to ask about under this new right.
So you mentioned freedom of information earlier. Couldn't the government have just achieved the same thing by amending the Freedom of Information Act to extend it to private sector social landlords?
Well, as I mentioned, FOI already applies to local authority housing providers. Council social housing tenants have already been able to make significant requests to their public authority landlords for 20 years now. Stairs is specifically aimed at PRPs, however, private sector social landlords, such as housing associations, which are exempt from FOI due to their non-public status. Bringing in the stairs standard continues to respect the fact that fundamentally FOI is all about use with public bodies, which spend taxpayers' money. But the stairs standard acknowledges the additional information and transparency duties which bind PRPs, private registered providers, by virtue of their special quasi-public function and role in society. It was just deemed disproportionate to extend the FOI Act to PRPs. The stairs-based standard is intended to strike a fair balance between the information, privacy and efficiency rights of PRPs as private organisations and the rights to know of their tenants, who have more than the normal consumer-supplier relationship with the provider of the roof over their heads. For example, unlike Freedom of Information Act, the stairs scheme won't be available for use by the press or by ordinary members of the public who are not tenants of PRPs. The standard is specifically directed at tenants and their representatives. It's proposed that the timescale for response to stairs information requests will be 30 days, while a further time for response may be applied for in exceptional circumstances, similar to a DSAR. Complaints of failure by PRPs to comply with the requests will be heard by the Housing Ombudsman. Stairs won't override the statutory rights of freedom of information or the General Data Protection Regulation, GDPR, or the Data Protection Act.
So you've just mentioned DSARs, or Data Subject Access Requests there, Stuart. Under the UK GDPR, how do DSARs and stairs requests sort of compare to each other?
Okay, so on a sort of very high level, there are similarities between stairs requests and FOIA requests or DSARs under the GDPR. For example, the receiving organisation, the housing association, can refuse a request if the requester, the identity of the requester cannot be validated, or a request is abusive or offensive, or if the request would take longer than 18 hours of staff time to fulfill. Also, there will be a complaints process to the regulator, and the stairs scheme will provide for a 30-day time frame for response. For the time window to respond to a DSAR, by comparison, is 1 month, and an FOI request is 20 working days. There is a much more detailed comparison of the proposed stairs obligations and the duties under the FOI Act contained in a long blog which I have written and which is currently posted on the URM website. It's a much more detailed comparison than the high-level one I've just given.
So finally, Stuart, what are the next steps on the stairs, if you'd pardon the pun there?
I see what you did there. Well, the regulator is expected to issue the stairs standard in its finalised form on the 1st of April this year, 2025. And we at URM will confirm when this happens. In the meantime, we have a page on our website dealing with URM's stairs-related service offering. I'll say a little bit about that. While the introduction of stairs is an entirely new development in the regulatory landscape for private registered providers, PRPs, URM's 2 decades of experience supporting organisations to meet data protection compliance requirements means that we are ideally positioned to help PRPs comply with the stairs standard once it comes into force. As with all our data protection services, URM can provide a gap analysis service where we can review all your relevant processes and determine what changes need to be made in order to meet the requirements of the stairs standard. As part of such a review, we'll provide housing associations and other clients with a prioritised list of remediations to address any shortfalls. URM can also support you in developing new processes and policies and in providing your staff with awareness training and your data protection champions with more in-depth training on how to deal with stairs requests. This training would include dealing with exemptions, timeframes for responding, when requests can be refused, and how to respond.
Amazing. Well, thank you so much for your time today, Stuart. And as Stuart mentioned, he has written a really detailed, really great blog on our website, which is called Stairs, a New Standard for Social Housing Providers, and we'll link that below. So, yeah, thank you, Stuart, and thank you everyone for listening today. If you've enjoyed this podcast, we would really appreciate it if you could spare a moment to leave a rating or review at ratethispodcast.com/InfoSec Insider. To listen to more episodes, you can find us on Spotify, Apple Podcasts, YouTube and Podbean.
Thank you for listening to URM's InfoSec Insider podcast. For more information, visit our website at urmconsulting.com.